The state of Michigan is now in session. The Honorable Mark T. Boonstra, the Honorable Brock H. Wurzel, and presiding the Honorable Miriam that all persons had a business herein, draw near to the attention shall be heard. That state of the United States, state of Michigan, and the stop.
Good morning, everyone. Welcome to the Michigan Court of Appeals. This is our second day of case call for panel 2 of the court's May 2026 session. My name is Miriam Saad-Bazzi, and I'm joined here today by Judges Mark Boonstra and Brock Schwartzel. We understand that these cases are important to the litigants and counsel, and I want to assure you that they are important to us as well. We have been diligently working on these matters. We have had the benefit of your briefing, as well as the work of our research division and chamber staff. We are familiar with the relevant facts and pertinent law, and so we ask you to focus oral argument today on your most salient points, why you should prevail, and what is critical for us to understand. Finally, we are hearing matters involving sexual assault victims, personal protection orders, and children. Because these proceedings are recorded, we ask you to please use initials rather than the actual name of any victim, child, or other vulnerable individual in those cases. With that, we look forward to hearing your oral arguments. One moment. All right, we're going to be calling item number 17, docket number 361558-T, People of the State of Michigan versus Kenneth Darrell Clay.
Good morning.
Good morning.
Court, Joel Kershaw on behalf of Mr. Clay. And as Judge Saad-Bazzi indicated at the beginning here, I understand that you probably understand my argument at least as well as I do at this point. So I'm not going to dwell on it too much because that's what the point of briefing is for. But I did want to just highlight a couple things really briefly. I would just in summary, I would say this. My argument basically comes down to this was a case in which trial counsel really relied exclusively on a self-defense claim, but conveniently forgot to include evidence of self-defense. And the only evidence or the primary evidence that would have supported that self-defense claim would have been Mr. Clay's own testimony. Mr. Clay wanted to testify, but like most people do that are in a trial for their very lives, relied on the advice of the counsel that was provided to him. And reviewing the entire record, trial counsel's advice here was simply not supported by any legal or factual basis. And in fact, when I look at the testimony the trial counsel gave at the Ginther hearing, I would still maintain, as I argued in my brief, that his testimony at the Ginther hearing about what Mr. Clay told him and why he didn't present the testimony of Mr. Clay was frankly not believable. Mr. Clay, in all the times that we have a story from Mr. Clay, he basically told the similar story. Yes, there are slight deviations, as is often the case when people are trying to remember things that happened days, months, weeks, years ago, especially highly stressful situations. And those kind of deviations do appear in the various statements. The one notable exception is the statements that the trial counsel at the Ginther hearing said that Mr. Clay had made to him. And that is particularly problematic to me. And so I did want to just very briefly focus on page 28 and 29 of the government's brief here. Right at the bottom, the brief states, and Mr. Taylor testified this version was unsupported by the record. There was no indication as Mr. Taylor testified that the home was broken into. There were no, so first of all, the fact that the home was broken into, the only evidence that we have that Mr. Clay ever even claimed the home was broken into would have been trial counsel Mr. Taylor's own testimony at the Ginther hearing. His statements, Mr. Clay's statements all throughout had been essentially that he was hearing somebody trying to get into his house, jiggling a doorknob. Jiggling a doorknob would not show signs of somebody breaking into the house. So I think that point that the evidence doesn't support Mr. Clay's story, frankly, only works if we believe trial counsel's version of that story, which is different than the other three versions of the story that we'd heard, but at the Ginther hearing during the competency evaluation and during his initial statement to the police. Goes on to say there were no shell casings or bullets found in the downstairs of the house, and victims were all found outside the defendant's home. I would just note as a matter of fact, I'm sure this court's well aware, not all guns leave casings behind. In fact, although it did not make it onto the factual record, so I didn't argue it at any point, I believe that in the police report, it mentioned that there was a revolver at some point recovered. As I said, that's, I guess, a somewhat off the record statement because it's not on the record. I could go through the additional facts listed here. I think the point that I'm really just trying to make here is, as the court's reviewing the briefing in this case, I would just ask the court to look very closely at the facts and the variances between the facts as told in three different accounts by Mr. Clay versus the fourth account, which only seems to appear in the testimony of Mr. Taylor, and review the trial court's determination of the witness credibility based on that information. I understand that the court has a review for clear error, but I think we can overcome that if the court looks at all of these facts. The other thing that I would point out is that there's an implication on page 29 of the government's brief, essentially stating that the only person that had any motive to be untruthful at the Ginther hearing was Mr. Clay. I can just say, as an officer of the court, I've been doing these cases, including probably dozens of Ginther hearings, going on 15 years now. And yes, there are some trial attorneys who will get up at a Ginther hearing and throw themselves under the bus for the benefit of their client. But those, frankly, are unicorns. The reality is that how truthful trial attorneys are at Ginther hearings runs a broad spectrum. So I wouldn't necessarily assume that one of these witnesses had a motive to tell the truth and one had a motive to lie. And quite frankly, given some of the actions I've seen coming out of the Attorney Grievance Commission, when this court finds ineffective assistance of counsel, it wouldn't surprise me at all that some attorneys might feel a motive to not be entirely truthful. So I would ask the court to consider that when looking at motives. With that, unless there's other questions from the court, I would just reserve a brief rebuttal, but that's all I have for the court.
No questions. Thank you very much,
All
Counselor.
right, thank you.
Good morning, Your Honors. May it please the court, Assistant Prosecutor Joshua Miller from the Oakland County Prosecutor's Office on behalf of the people. I am substituting in for Assistant Prosecutor Danielle Walton, who did the Ginther hearing as well as the brief in this case. She's no longer with our office. I have familiarized myself with the pleadings and the proceedings, so I can't answer any questions the court may have. This case really comes down to a very simple matter. The defendant affirmed under oath that it was his choice not to testify. He did so in part based on the advice of counsel. Counsel's advice, as was explained at the Ginther hearing and is outlined in the brief, there were multiple reasons why he advised defendant not to testify, not the least of which is that the prosecution did not use defendant's prior statements to the police in its case in chief. Those would have come in rebuttal if defendant had testified, and they would have opened defendant to not just impeachment, but completely would have eviscerated his credibility, crystallized a possible motive for the shooting, and gone to elements of premeditation and deliberation. So counsel proffered these reasons to the court at the Ginther hearing. The trial court found the testimony credible, found defendant's testimony was not credible, not just based on the surrounding facts, but also on its own evaluation of the witnesses. And as brother counsel pointed out, this is a clear error standard if we're talking about a credibility determination. And it simply is not clear error based on everything the trial court had in front of it for it to have found trial counsel credible and defendant not credible. So unless the court has any specific questions for me, I would just rely on Ms. Walton's brief.
What about opposing counsel's point that the trial court indicating that the trial counsel had no motive to be untruthful seems a bit of a stretch?
I agree with that, Your Honor. It's a bit of a stretch, but at the same time, he has much less incentive to be untruthful than the defendant does. He's not looking at life in prison ×3.
Well, I think it's, you can have different motives. You can have a motive to be untruthful, to kind of cover your butt. You can also have a motive to be truthful because that's what's required of the court and you're an officer of the court. So,
But I do think it is telling, though, Your Honor, that the version that trial counsel said, this is what defendant told me, came before he had any idea as to what defendant had testified to. So it's not like he was responding to something and making it sound worse. He didn't know what the defendant had said. And no, when he was told this is what the defendant says his version of events was, well, no, that's, as I said, that's not what he told me.
Okay.
So it was something that was already on the record. Thank you. Any other questions?
Where does Walton go?
She went up to Genesee County. She is their chief of appeals now.
Oh, okay.
Thank you very much.
Thank you.
Rebuttal?
Yes, thank you. Just very briefly. First of all, I often hear in these cases when this argument comes up, well, the defendant chose not to testify. And if we were arguing, if the argument was about the right to testify, that would be a cogent point, but on an ineffective assistance, that doesn't necessarily settle the matter. He chose not to testify because he relied on the advice of his counsel. The other thing I would just respond, one more thing I would respond to is based on the advice of counsel. The argument essentially was that had Mr. Clay testified, that would have opened the door for the government to enter, to bring into evidence Mr. Clay's statements. I have not seen any reason, I can't think of any reason, reviewing the rules of evidence, I can't find any reason that they were not entitled to bring those statements in during their case in chief. They chose not to. Perhaps trial counsel thought, wow, they really messed that one up and didn't bring that in, and I don't want to open the door. But that really seems quite a stretch here. We have a seasoned trial attorney that's trying this case for the government. In my years of doing this, I've never seen any prosecutor's office throw a rookie attorney into a murder trial. I don't think that was the case here. So I don't think it was an oversight on the government's part. They simply decided it wasn't strategically in their best interest to bring those statements in during the case in chief. So I think that that rationale runs hollow. The last thing I would point out is when we were, and Judge Swartzel, you asked about the incentive to be dishonest and things like that. And one of the responses that I heard was something to the effect of that trial counsel had told this, had basically given his account before Mr. Clay had testified. Therefore, he didn't even know what Mr. Clay was going to testify to. But the reality is, Mr. Clay's testimony at the Ginther hearing was the third time that we have documented that he told the story of what happened on that particular day. Certainly, if trial counsel had read the file and had adequately prepared for trial, which I'm not disputing that he did, I presume that he did so, he would have read the initial police interviews in which Mr. Clay gave a very similar account to what he gave at the Ginther hearing and his statements during the competency evaluation. So I don't see how the fact that he testified first at the Ginther hearing somehow means that he couldn't possibly have fabricated or stretched the truth or anything about what he had heard. So that's really all I have in rebuttal. And once again, if the court has any questions, I'm open to them, but if not, I think I'll call it a day.
Thank you
All
very
right,
much,
thanks so much.
Counsel. All right, this matter is submitted. Calling item number 18, docket number 373645-G, People of the State of Michigan versus Carzel Huffman. Morning, Your Honor. Susan Walsh on behalf of Carzel Huffman. Contrary to the first case, this is a really straightforward case, really short, half-day trial, only a few witnesses. The most salient point is that there really was no pre-trial in this case. The hearing never, the final pre-trial was never held because of a problem with the writ. And so my client comes in the day before trial
and has to get everything taken care of that day and make up his mind about plea offer. And argued that that was not due process and that denied him a fair trial. So I think it's all spelled out in the brief, and the opposing counsel also filed a brief. They're not here, but I think everything's in the pleading. So unless you have any other questions,
I don't.
it's really straightforward. Okay, thank you.
Thank you very much, counsel. This matter is submitted. Calling item number 19, docket number 369-581-D, People of the State of Michigan versus Gabrielle Marie Brantley.
Good morning, judges. My name is Robert Tomac. I represent the appellant Gabrielle Brantley.
Mr. Tomac, before you continue, would you like to reserve time for rebuttal?
Not likely.
Okay, go ahead.
The prosecutor's right. The review is de novo. I'm getting this right from the prosecutor's brief. This issue concerns the interrogation. I'll address the issue concerning interrogation. And actually, the issue is invocation. And I would point out initially that at 16:20 in the recorded interrogation, the defendant says, "I need representation." At 23:14, the defendant says, "Can I call my lawyer?" "Call my lawyer, please." At 49:20, the defendant says, "I need a lawyer." Now, this interrogation the interrogator in this case was very aggressive. The objective here obviously was to create a intimidating environment. And this defendant, even though she was studying to be a nurse, or she was a nurse and so forth, there was no way that she was prepared for this intimidating interrogation that she was subjected to. Now, what I argue here is that once the suspect, the defendant, asks for an attorney, the interrogation should cease immediately.
Well, Counselor, didn't it stop immediately? When she asked for an attorney, they stopped questioning her. And I believe at one point they both stood up and she's like, no, I want to continue, and proceeds to do that. And at each time that she brought up a lawyer, the officers stop and clarify with her, does she want a lawyer, explaining that if she's requesting a lawyer, they would leave, that they wouldn't be able, they would end the conversation there. And at each time that and she is the one that instigates the continuing conversation.
Your Honor, this interrogation, when you view it, was not a situation where the defendant makes a request and the interrogation stops. The interrogator stands up, towers over her, and starts telling her what the consequences are going to be. Here's one example where she makes the request at 49:20. She says again, "I need a lawyer." And he says you have to, I mean, I'm sure the courts listen to it. In a loud voice, he says, "I'm not doing this shit with you." And every time that she would bring this up, they would intimidate her with the consequences of what was going to happen. She was totally overcome by the methods that this interrogator was using. And what I'm saying is that Miranda.
Well, Counselor, I did watch the video and they did stand up and they did explain at multiple occasions that they were going to end the conversation. And frankly, there was a conversation where she was requesting an explanation of what was happening at multiple times too. In fact, begging them to continue to speak with her at one point afterwards. And so I and tone inflection changed throughout the conversation as well. Sometimes it was louder and sometimes it wasn't. And so I'm, it appears to me it wasn't unequivocal that she wanted a lawyer, that she would bring it up. They would tell her, we're going to stop talking to you and explaining that they can't, but she appeared to want to tell her story.
Uh, I'm not sure if, did you, I would say this, the request was equivocal. Your Honor is saying it was not equivocal?
Well, she mentions the lawyer, but then the conversation, they clarify from her multiple times, do you want to continue? We need to stop talking to you if you want a lawyer. And then she requests a continuing interrogation.
Yes, they're practically shouting at her. I mean, she doesn't know what's going on. She thinks if she asks for a lawyer, the roof is going to cave in on her. I would just point out, there's a case here that I found, People versus Ansley, Michigan Appeals, 18 Michigan Appeals 659, and it deals with Miranda. In that case, for some reason, Miranda wasn't applicable, but the opinion says that if the suspect in any manner, at any stage of the process, wishes to consult with an attorney, the questioning, there can be no questioning. The questioning has to stop.
Well, that's, so Edwards v. Arizona indicates that you're correct. When a request for a lawyer is made, the questioning stops unless the defendant reinitiates the conversation. And to Judge Bazzi's point, it appeared your client reinitiated the conversation on multiple occasions. Every time that the police got up and said, okay, we're done talking, she would say, no, I want to keep talking. I want to. And I mean, I think part of why the cops were getting a little loud was their frustration with your client going back and forth on whether she wanted a lawyer or not. But be that as it may, even if they crossed the line of Edwards v. Arizona, let's assume that. What was the prejudice here? Because I think, if I recall correctly, she didn't admit any guilt during that second interview. And so even if she was a little evasive or a little, intimidated or whatever, I really didn't see the point of that video at all.
Okay.
Pro or con.
Yes. How I would respond to that is Miranda covers exculpatory as well as inculpatory statements. If that interrogation played before the jury cast her in a very poor light. I mean, she looked as guilty as heck. And so by playing that video,
she looked guilty, or she admitted she was guilty.
no, she looked guilty.
I don't know what that means.
Well, she didn't make any exculpatory or inculpatory statements. She did not. She did not admit to a crime. But what I'm saying is that the impression given, I submit, by that interrogation, showing her in that position where she wasn't able to make a coherent response to these demanding questions put upon her, cast her in a poor light in front of the trier of fact.
Do you have a case that you can point us to where it says allowing statements in that make someone look bad but is not actually inculpatory is sufficient under Arizona or Edwards v. Arizona?
Well, I would point the court to a very informative law review, 69 University of Cincinnati Law Review 863, which deals with this situation of equivocal requests for an attorney. And the upshot or the conclusion here is that since Miranda, there has been a lot of controversy having to do with these requests that are not definite. And the conclusion, I mean, in the case law is that once the request is made, all questioning stops. Now,
I'm, for purposes of my questions, I'm conceding that the questioning should have stopped, and maybe this video should not have been shown to the jury. Grant that. All I'm suggesting is, what was the prejudice here? I don't see how this video really added anything to either side, frankly, because again, she didn't admit guilt. Did it show her that she was evasive? Maybe, but it also, I think defense counsel would argue, it made her look like she was very scared, very nervous, like an innocent person would be when being yelled at by two cops. So I just don't see the prejudice here.
all right, I would say that she would have been her due process rights would have been better served by this video, this interrogation video, not having been shown to the jury, because it looks like she's evasive, and she doesn't know. She at one point and at several points she asks for an attorney, but once she makes that statement, it seems like all hell breaks loose. I mean, they stand up and they, do you know what's going to happen, and so forth, and in a loud voice, and she gets intimidated, and then decides it's in her interest to continue. In other words, she's made to understand that there's going to be bad consequences if she continues with her demands an attorney. What should have happened, I submit, under the prevailing case law here, the way that the law stands now after Miranda, is that once that initial statement is made, just stop and send her back to detention. And that's our position. Thank you, judges.
Thank you very much, Counselor.
Good morning. May it please the court, Deborah Blair, on behalf of the people, the Wayne County Prosecutor's Office, the appellee in this matter. The defendant raises two issues in her brief on appeal. The first issue was whether there was sufficient evidence to sustain the verdict of first-degree premeditated murder. We submit, taken in a light most favorable to the people, that there was more than sufficient evidence to show that the defendant killed the victim with premeditation and deliberation.
Is that the case even if we were not to consider the video of the second interrogation conversation with police, whatever you want to call it?
Yes, I believe so, because there's nothing substantive that comes out of that second interview. The defendant never gave an inculpatory statement. She never admits involvement in the murder. She is evasive and she does not explain fully her actions. She gave a first statement and she was allowed to leave. The second statement is when she was arrested. Even if those statements were not entered, there was sufficient evidence. There was an eyewitness that saw a person, a female with long hair, in a silver car, which the defendant owns.
I want to get back to the second statement. It escapes me why it was even used, because whether or not it violated Edwards v. Arizona, maybe she did reinitiate a conversation, but it was certainly it got up to the line. And there were certainly, I think, good faith arguments for why maybe this interview should not have been allowed, because she did ask for a lawyer and then she equivocated. So I get that. But given the kind of lack of evidentiary value, it seems odd that a prosecutor would even offer it up, given given at least the very good faith Edwards v. Arizona argument, I don't get why this second video was even used.
Well, I think it gives context to the relationship between the defendant and the victim. The
So
defendant,
it has some informative value, it had some evidentiary value, even if it wasn't inculpatory.
the defendant makes statements about how she knew the victim, how she knew the victim was involved with her boyfriend, Mr. Stevenson, how she knew that the victim was pregnant, expecting a baby, that they went to school together, that they had similar schedules, that she knew that the truck that the victim used to drive. So there was some information in that statement that would be corroborative of the other facts of the case.
That makes sense. Thank you.
In regards to the second statement, the people believe that the defendant's request for an attorney was then followed by a reinitiation of conversation with the investigator. And the investigator repeatedly told her she did not have to speak to them, and even asked if she was sure that she wanted to continue. She said she was. So under those circumstances, we do not believe the statement was involuntary or in violation of Miranda. Therefore, we ask that you affirm the defendant's convictions and sentence. Thank you.
Thank you very much, Counselor. Rebecca? Thank you. This matter will be submitted. Calling item number 20, docket number 374-376-D CB versus Lincoln Park Public Schools. How much time would you like to reserve for rebuttal?
I would like to reserve 5 minutes for rebuttal. Thank you.
All right, thank you very much, Counselor. You may begin.
Good morning, Your Honors. Andrew Malik on behalf of defendant Lincoln Park Public Schools. So I will, of course, keep it brief and stick to the main points of our argument. We are asking that this court reverse the trial court's decision denying our motion for summary disposition on the basis of governmental immunity. So this court has held that governmental immunity applies to a government agency without regard to an employee's gross negligence. All of the allegations against the defendant in this case arise out of 1407 subsection 1, which governs governmental agencies, which provides broad immunity from tort liability for an agency engaged in a government function. In this case, plaintiff does concede that Lincoln Park Public Schools is a government entity that was engaged in a government function at the time of the alleged incident. Plaintiff's argument attempts to create an exception for governmental immunity for a government entity that simply does not exist. First, by arguing that, first in general, there is no exception to governmental immunity for gross negligence. Everything regarding the gross negligence exceptions arises out of subsection 2, 1407 subsection 2, which deals with employees or officers, not the entity itself. So first and foremost, there is no exception for gross negligence with regard to the government entity. And the only way to avoid immunity would be to find a statutorily mandated exception to the statute, which there simply is not one that applies in this case. So broadly speaking, there's no exception for gross negligence. With regard to their argument about negligent hiring or supervision or training of teachers, this court has also held that, number one, the operation of a public school is a government function, and that hiring and training teachers is also a function that is the essence of the government. In Willoughby versus we cited a case Willoughby, which kind of goes into that a bit more, which says that the school code, which expressly provides that a board or a school district has the authority to hire and train teachers and to continue their contracts, is part of that government function. So in that sense, they are exercising a government function as well. So I think those are kind of the main broad points, is that there's just no exceptions that they're trying, like the ones that they're trying to make. Going to their argument regarding ultra vires acts, it's sort of the same thing. Trying to make an exception for gross negligence, or an exception that just doesn't exist in the statute. But I also think that the concession that defendant was engaged in a government function kind of defeats this argument that something could have been ultra vires, because nothing here was a non-governmental function, right? It was supervision of a student, and it's explicitly stated that even transportation en route to or from school is part of that government function.
Am I correct that below plaintiff's theory was that this injury occurred on the bus, or getting on the bus, or something to do with the bus? But on appeal, there seems to be a shift, and there's I believe a public building exception argued. Is there anything in the complaint or anywhere below where the public building exception was argued by plaintiff? Do you know?
Your Honor, the public building exception was not pled in the complaint or in response to the motion for
And a
summary.
bus, and I don't mean to be cute about it. I mean, sometimes we have strange definitions. A bus, it's a large thing. That does not fall under the definition of a public building, to your knowledge, correct?
To my knowledge, no, it does not. And that kind of gets into the last point I wanted to make, was now on appeal, they are trying to go into the public building exception with regard to this incident. But not only was it not pled below, and I believe it was waived, and it's not properly before this court on appeal, but they also didn't comply with the requirements of asserting the public building exception. So, they didn't comply with the 120-day notice that was required of them if they were going to plead that. And also they don't plead the specificity that is required under the public building exception to say exactly what was defective with a building that caused this injury. So they're kind of making conclusory, well, they're not kind of making, they are making conclusory statements about, well, there must have been something wrong with the school building or the bus that caused this, but that's not specific enough under the public building exception. The last point I'd like to highlight is the trial court, when it denied our motion for summary disposition, was somewhat concerned with whether or not the parties needed more discovery. And I actually cite, it's an unpublished case, but I think it's instructive here. It's Monteleone versus Macomb Intermediate School District. Essentially, in cases where it's a governmental immunity argument, there's no further discovery that's going to change the fact that it's a government entity that was engaged in a government function at the time. So the concern over more discovery, while it might uncover other information about the underlying incident, the statute is meant to provide immunity to a government entity from suit altogether. So the concerns about needing more discovery or anything like that, I think are somewhat irrelevant in cases such as this. So unless there are any other questions.
Yeah, thank you very much, Counselor.
Morning, Your Honors. Emerald Altwheel standing in for Attorney Tom Krall on behalf of Plaintiff Appellee CB. I just want to begin with addressing the fact that Plaintiff Appellee does not concede to anything at this point in time, specifically because one of our main arguments in the brief is that a motion brought under 2.116C7 is completely premature. This is the price a governmental agency pays for filing a motion for summary disposition in lieu of an answer, and then proceeding to cherry pick evidence that favors them, showing that they're not liable for any potential injuries.
What is the statutory exception to governmental immunity here that you are specifically pursuing?
There are several, because at this point.
Which ones are they specifically?
So, one of the arguments is that, the governmental agency themselves are directly liable for their own gross negligence. Another
But
exception,
that's, I don't know where in the act do we find that specific statutory exception?
well, that's the thing is, it's the legislator's definition of how they interpret the language within the statute itself. According to 691-1407 subsection 1, it literally says that the Governmental Tort Liability Act does not modify or restrict governmental immunity pre-1965. So looking at this under the window of the pre-1965 suit before the Governmental Tort Act was enacted, a school district or a governmental agency was liable for its own reckless conduct. And specifically, they had a common law duty to safely hire, train, and supervise staff. And so that's the way that I'm interpreting the statute, and that CB believes that.
So there's a pre-1965, what's the name of the decision you want us to rely on from the pre-1965 case law?
There weren't any that were cited in the brief. However, they rely on Yoches, the city of Dearborn. And that case simply settled the fact that a governmental agency can be liable for their own reckless conduct, vicariously liable for their conduct of their employees.
Let's assume we disagree with you that there's basically a giant hole in the Governmental Immunity Act based on all pre-1965 case law. So let's just assume that there's a general grant of immunity for governmental agencies like this, like a school district. Is there another specific statutory exception that you can point us to that you're relying on?
As far as the holding Lincoln Park Public School.
No. Let's assume that your pre-1965 argument doesn't prevail. You said you had multiple statutory exceptions that you were relying on. And I'm asking you, so what are the other ones? And what are the specific provisions in the statute that you're pointing to?
So another exception that we're looking to proceed with is the public building exception. This, as you mentioned, was not referenced in the complaint or the brief at all, and that's simply because
the brief below.
No, the brief that was submitted to the Court of Appeals was addressed this issue.
Okay, you're confusing me. I think you just said it was the public building exception was not addressed in the complaint, correct?
Correct.
And was it addressed in any of the briefing below in the trial court level?
There was no opportunity to. I mean, they filed a motion for summary disposition in lieu of an answer, so there was no time to amend the pleadings.
Did you reference it in your brief in response to the summary disposition motion? Did you argue the public building exception in your brief opposing summary disposition?
No.
Okay.
But again, because the complaint is fresh and they filed an answer in lieu of I'm sorry, I apologize. They filed a motion in lieu of an answer. The fact that they didn't allow for discovery to occur, it still gives plaintiff appellee the time to amend their complaint to include additional causes of action, such as the public building exception. So that's why it was brought up in the Court of Appeals.
But you didn't argue in the trial court that you wanted to amend to add that allegation, did you?
That's because immediately after the ruling on the motion, there was also a motion to consolidate because there was other staff that were plaintiff appellee was pursuing. So they had granted that motion to consolidate. And then immediately after, there was a hearing on this motion for summary disposition bringing us here, which I mean, immediately after the court granted they sought leave to appeal. So,
You're
and a
the-
motion for stay.
The theory of the case would seem to have to shift if you're going to rely on the public building exception, because as I read your complaint, it relied on, or it asserted that the injury occurred on or getting onto the school bus. Now, you seem to be suggesting that no, the injury actually happened in the school building. Those are two different locations, two different things that the child was either in or getting on. So what are we supposed to go on? Are we just supposed to say, well, either or have you landed on a theory of your case?
No, absolutely. There is a theory on the case. And so as we were preparing for this brief and the oral argument, there was a police report, something that the Lincoln Park Police Department had conducted an investigation, which is how we got some of the video surveillance evidence, because the police department requested this. So one of the officers in their notes for the police report indicated that the plaintiff's injury, CB's injury, was clearly visible on the bus camera before he was getting on the bus. So there was camera footage pointed directly at him with the supervised teacher who was holding his hand, and another staff member. We don't know who that person is. They're just Jane Doe at this time, but they were in communication with one another. And CB is shown in this video footage holding his hand up with the severed finger up to the face of the teacher who was holding his hand. So, and this is documented in the police report.
So it's fair to say the injury did not occur on or about the school bus. It must have occurred somewhere before that. And I think your theory is that it happened in the school building, correct?
Correct.
Okay.
And so there's another, the final exception that, we're looking to argue here is that they were in the act of a ultra-virus activity. And so ultra-virus just means that it's outside of what the scope of employment is. So it becomes a unauthorized.
What was outside the scope of the governmental activity here?
So there was a case that we cited, which was McCann versus Department of Mental Health, where the court held that a governmental function only includes activities authorized by law. So here, being the teachers in the school district, being employees of the public, they are mandated reporters. And so for 5 employees to, simply ignore a nonverbal autistic child with sensory deficiencies with an urge for touching, who requires one-on-one care, simply is the ultra-virus conduct. So if this child required one-on-one care and hand-holding everywhere that he went, there is no way possible that a teacher or an employee of the school district could not have observed or saw something that could conclude that this is the cause of the injury. In fact, there's a video footage of the hallway as CB was exiting the classroom. And one of the conduct that was observable was the teacher who was holding the injured hand did not look at this child once. This is something that, per his IEP, which is also mandated under Michigan law through the IDEA Act, it's a violation of the IEP. So these employees were essentially taking a gigantic frolic, and so they essentially abandoned their government role. With respect to the governmental immunity exception under the public building exception, we just look at that the lack of safety features with respect to the the building itself. So for example, because CV had this urge to touch things and he required a one-on-one care, we believe that his finger may have been stuck in between a door jamb, or that there was a crack or a crevice in the wall. These are safety defects, specifically because there was a case, Bush v. Oscoda area schools, where the public buildings exception was held to be applicable with regard to lack of safety features. And the facts of that case are simple. There was a math classroom that was converted to a science classroom. A child was injured when a Bunsen burner exploded. And so there was lack of safety features. The court held that this was a defect in the public building itself. They looked at whether or not there were special certain needs required to make this classroom safe. And so if they knew where CV's route was on a daily basis and per his IEP, they should have made that area where he was going to be safe. That includes doors, classrooms, bathrooms, everything. So that's simply the main reason. And so if this court doesn't agree with the fact that a governmental agency can't be liable for their own gross negligence, then we would just like to argue those other exceptions, such as there was no governmental conduct within the scope of employment, so it was not a governmental function at the time, or that something occurred within the building itself that should have been prevented. And so we just ask that you affirm the trial court's order. Thank you.
Thank you, Counselor. Rebuttal?
Just very quickly, I think some of the arguments that they're making now are very clearly different than the arguments that they made on appeal and below. With regard to the first statement that they're not making a concession about anything, their complaint, which is Exhibit A to my brief, it's page 6, paragraph 50, explicitly states that the defendants were acting within the course of their employment or within the scope of their authority with Lincoln Park Public Schools. And then in their response to our motion for summary disposition, they state that plaintiff is not in dispute that defendant Lincoln Park is a governmental agency within the definition provided under the statute, nor is plaintiff in dispute that the government function of a school district includes the supervision of students while at school and while en route to or from school. So I think that concession was made. And again, just kind of bringing it back to the overarching point, which is that the purpose of governmental immunity in the statute 1407, 691 1407 is its immunity from suit. So when they start getting into details about the underlying facts of the case, and well, we have this video, we have this and that, it's again ignoring the fact that it's immunity from suit altogether, and that Lincoln Park Public Schools is a governmental agency. They were engaged in a governmental function. It's the supervision of children at school. And really none of the arguments that they presented change the fact that there isn't an exception in the statute based on these facts. And then lastly, again, the public building exception, it wasn't raised below. There was a 120-day notice requirement. So if they were going to raise that, they filed suit, they needed to be prepared with what their case was going to be about, and to look now and say, well, we want to amend the complaint and add new defenses or new theories of the case or what have you. It's inappropriate at this juncture. They could have had it in the complaint. They could have, put it in their response to our motion for summary disposition, which it simply is not there. So those were kind of the points I wanted to highlight again and sort of just bring it back. But if there are any other questions, I'd be happy to answer them.
There are no questions. Thank you very much, Counselor. This matter has been submitted. Calling item number 22, docket number 374-590-D, Stephen Mamat versus Robinson Realty and Management Group. How much time would you like for rebuttal, counsel?
3 minutes should do it, Your Honor. I'm not planning on speaking too long. Your Honors, as you know, this is a case involving fraud involving the sale of a home in the Boston Edison district, which is a historic district in Detroit. This appeal centers on the allegations against the real estate broker and her company. It's our position that they can be liable for silent fraud. I don't think the trial court quite understood our position, so I want to make sure this court does. The trial court basically ruled that the agent could not be liable for fraud because the seller's disclosure statement specifically applies to seller statements, and there's a warranty that it doesn't involve the agent at all. We have no issue with that whatsoever. We don't believe that the agent has an independent obligation to go and research everything that's in the seller's disclosure statement and make sure that it's right before turning it over to a buyer. Our position is that once the agent becomes aware that something is incorrect or false, it is material to the sale, she has an obligation at that point to speak up and say something. The trial court dismissed this case only because it's not her statements. She never got to the second part of the argument, which was that she does have an obligation to speak up if she knows the seller's disclosure statement is inaccurate. So that's number one. Number two, she relied on the release to dismiss this case. And it's our position that the release falls with the contract. In this case, we are alleging that my client was induced to enter into this contract because of representations made in the seller's disclosure statement and the failure of her to make corrections to that seller's disclosure statement once she found out that the windows had to be replaced, etc.
Is the HDC approval a permit that would have to be obtained? I mean, when I think of a permit, I think of, a permit that you have to get from the city or from the village. I don't think of it as home HOA approval. I see those as just different. So
it's my understanding it's a permit. You have to get permission to do exterior work on the property, just as you submit a permit to get work done through the city. It is a requirement.
I mean, yeah, but you changed it a little bit. You said, well, it's a requirement, it's permission.
Yeah.
Is it a permit? Again, I think of a permit as kind of a specific thing, not just my HOA saying, yep, you can put that fence up. I mean, is it all just under the broad category of permission?
I don't know if there's actually a permit that's actually, issued like the city would issue a permit necessarily. But there is a requirement that you fulfill these obligations. And if you don't, that the problem, the improper change to the property runs with the land. So that was spelled out by the HDC to both broker and to the.
Just as a practical consideration, does the HDC do anything? It seems like the HDC has known about this for a while, and they send a letter every August, and does nothing get done?
They do work with the homeowner. In this case, they said they would work with the homeowner in order to find a solution, because there are more than, like, for example, one set of windows that can be replaced with the vinyl windows. So there are different options. They'll work with him to make those corrections, but is it required? I assume they could go to court if they wanted to, just like a homeowners association could do so. And if you improperly to change your property, I have restrictions on what I can do in my neighborhood, for example. We have to go and get permission if we want to change anything so nothing looks cookie cutter like. That's part of my subdivision HOA. So I have to get permission. The failure to do that, I suppose, they can get an injunction and go to court and stop that from happening. But
it may not have anything to do with this appeal, but does the HDC actually do anything? I mean, do they ever go to court?
That I do not know. Okay. It's not part of the record, and I do not know whether
it seemed like these letters would get sent every August, and they're like, okay, well, you're out of compliance.
Right, they do, but there's a problem when it goes forward now for my client. My client now will have to disclose this if he wants to sell the property going forward. And so his house is now much less valuable than it was prior, because replacing windows on a home in the historic district when there's so many windows, it's going to run over $100,000 by his estimates. And so it does become a bit of a problem for him going forward. Either he has to fix it or he's got to eat that cost when he sells the home. So
And this appeal does not involve the seller, correct?
it's not, that is back at the trial court. Now, we tried to resolve things through the HDC, just letting you know, the HDC, we tried to get a waiver to allow these windows and the beams and so forth, and they said no. And so we're back in court now. Yeah, well, we refiled it. So that's where we are with that. Going back to the release, though, I think this is fraud in the inducement, and therefore the release falls with the contract. So I don't think there's any basis for the trial court to say that we released any claims in this case. With respect to the final thing I want to raise is with respect to the amendment of the complaint. Not only does the agent know that these windows have to be replaced because they're vinyl windows and she has knowledge of this, but she goes ahead and advertises new windows. And the trial court said, oh, they are new. That's okay. They're new windows. That's accurate. It's not a misrepresentation. It is very misleading to say that your new home, that you have new windows, that goes to the value of the home, what you pay for the home. You cannot withhold the fact that, oh, we do know that they have to be replaced, by the way, but they are new. So it can't be fraud. That argument to me does not fly at all. I think it is a misleading statement. It is fraudulent. And we should have been allowed to amend the complaint to allege that the listing was fraudulent. That's all I have today, unless you have something else. Thank you.
Thank you very much, Counselor.
Morning, Your Honors. For the record, Brian Hirschfussbring on behalf of the appellees, and I'm stepping in for Catherine Wainwright-Shensky, who's my partner and is out of the country. Enjoying herself, I'm sure. If I might, I generally have my own order to go, and I understand you've read the briefs in this matter. But if I have your consent, before I actually give you just a few minutes of argument, I'd really like to kind of address first a couple of comments that counsel made for the appellant, because I think it's important. One of the things, and I think the overriding issue in this matter, is if you have a duty to disclose, that's one thing. And clearly everybody, and you just heard that from counsel, certainly on the seller's disclosure, it's the seller's disclosure statement, not the agent. And there's a specific carve out that says this is not to be used as a warranty and it is not a representation by the agent, et cetera. I mean, it's all in there. And so it tells you, do not rely on any of this. And if you've heard, and that's, when you have the merger clauses, it tells you everything is in here. And if it's not in here, especially if it is important to you, put it in there. And if it's not in there, you don't get the right to come later. Where counsel is off is one small issue. He says, if you later learn that there is information that may make the seller's representation inappropriate or wrong, then you are duty bound to give that information over. And that he's 100% wrong on. The only time the law requires a modification is if you made that representation. And based on the law that's in the brief, one of the things that you need to do is that you have to be asked. Again, I didn't write this law, we're following it. And what it says is if the buyer says, by the way, do we have new windows that comply with the HDC and I won't have any issue with that? If my client, the agent, says, absolutely, now she has made an affirmative representation. Now she is duty bound to go back and say, if I do have information later, I must, because I did give information.
What if the buyer asked the agent right before closing, is there anything in the seller's disclosure statement that is no longer accurate? Could it be that broad of a question to your client and then put a duty on your client to correct any now misstatements in that disclosure?
So the short answer is no. And let me explain why. I've been doing this, the cases that come out, we've made some of the law on these issues. One of the hardest thing is, again, here they say, oh, the agent got notice about, some deficiencies. The agent says, no, I didn't. Okay. But what happens in these cases is that somebody made a representation and induced me so that I would move forward with the transaction. And that's why the purchase agreements are very for the most part, thorough, and they have language in there that says things like this. Paragraph 26 of the purchase agreement. It not only requires the purchaser's due diligence, but it answers your honor's question. It says to ensure intended use of premises, it is recommended that the buyer research square footage, building and use restrictions. And let me just stop there for one moment.
Hold on. I don't, maybe we're talking past each other. You gave a very specific situation in which your client would be required if they were specifically asked, are there any problems with the windows? Something like that.
And she knew.
And she knew. Then she would have a duty to, mine was, well, how about let's generalize that question a little bit more, which was, agent, do you know of anything that has been disclosed to me to date that is no longer accurate? Would that more generalized inquiry put a duty on your client to say, okay, well, there's these three things I'm now aware of, A, B, C? Or would your client be able to sit there and remain silent and say, I don't know?
Remain silent. And here's the reason why, because the law is clear. You are a seller's agent with an antagonistic relationship. That's the case law usage of terminology. It's an antagonistic relationship. So my job is to be there for my seller. And what probably would happen in a case like you're asking is you would shift and say, here's the seller. You need to direct that question to the seller.
See, that's a little bit where I'm getting confused, because you are the seller, your client is the seller's agent. And therefore, what the agent says is on behalf of the principal. The agent is acting on behalf of the principal, at least in many ways. But it seems like in this one way, the agent gets off scot-free. And this is all assuming your client actually knew about the windows.
As I said, the purchase agreements were an evolution. They over the course of years, these are the types of things. You look at the case law, these are the types of questions that get asked. Just the same way you're asking the question, somewhere along the way, a buyer says, I asked specifically that agent a question like, are there any representations that were made that you now know are not true or otherwise? And then I would say, in direct response to you, that's how you have paragraphs like paragraph 34 that said, if anybody made a representation that's not in this purchase agreement, then you have the addenda that come later. But if anybody, and I identify that specifically on page 2, and we do it again later in the brief, but the parties acknowledge that they are not relying on any representations or warranties that may have been made other than those in writing, and the parties waive and relinquish any and all claims or causes of actions against the brokers, their officers, directors, employees, and other agents for the conditions of the property or the performance of the agreement by the parties. I would guarantee your honor that somebody didn't just sit behind a desk one day and say, I got a great idea. It came because the question that your honor is asking is, what happens if a buyer claims, well, I relied on a representation or the agent said something to me. So that's why these purchase agreements provide. Now, I will tell you this, if, again, generically speaking, because again, it didn't happen here and it's not alleged, but if something like your honor asked happened and somebody says to me, what would you tell your agent to do? I'd say, you tell them, here's the seller, it's his seller's disclosure, because the statute says if there is information that says you, the seller, now have information, you, not the agent, are duty bound to update your seller's disclosure. And there are consequences if the principal doesn't do what they're required to do. And so, there's a whole other series of issues that would arise if that happened, because then the agent would say to their principal, you need to update this because you now know you've got an issue. So again, but that doesn't help the buyer directly. That's between the principal and the agent. So if the seller sues the agent and says, why didn't you tell me I had an obligation to update this? The statute, the codified law says I need to update it, and you didn't tell me. Now I'm on the hook and I'm being sued over it. Again, it's litigation because of a duty that gets breached because the agent should have instructed that seller, you need to update it. not me, your agent, you, the seller, because that's what the statute requires. Okay. All right. And I do want to identify also that as it relates to the realty company and as it relates to the agent themselves, I think that there's three things, and we are certainly asking the court to affirm the lower court's decision, but I think that there are three main areas. One, I've just gone over in response to your Honor's question, paragraph 34, there is a release, there is a waiver, and the only time that can be set aside and be negated is when there is a situation where you commit fraud in obtaining that release. Nothing else. You must commit fraud in obtaining the release, and that's not even alleged, and certainly that's not what happened over here. Two, the other thing that might arise, okay, is that a duty of disclosure. Again, we went through that, and I think that's what my preamble, that's kind of what precipitated the question of Your Honor, is that if you make the representation, now you've gotten the obligation of information comes to you. If you've never made the representation to begin with, you're not duty bound. Again, as I said, I think the short answer to that is you say to your seller, you've got an obligation under the statute, do it. And that's where you begin, that's where you end. You don't represent any interest of the buyer. And lastly, that's what you've heard from the appellant is that all of this information, it's out there. So that's one of the things that happens in these fraud cases. And we've briefed this, and it identifies that if you have a case of fraud, but you had the information available to you, that's part of your due diligence. You must go out there and get that information. And that's one of the things that paragraph 26 of the purchase agreement tells you to do in paragraph 28 regarding municipal inspections. So if they go out there, they do their due diligence, they know both addenda, the 2 November addenda, they identify, that there was an inspection, there were going to be some repairs, and there was even a holdback on one of them, $2,500. But they identified that you've got to go to the commission, the HTC, it's right in there. So it's not like they don't know about it. And certainly if you're buying in those areas, and they're beautiful homes, you're buying in that area, you generally understand you've got some obligation because they do control you. And I think one of the questions that was posed is what happens in the ordinary course? Do they sue? I think what's important is that it does follow the property, and whether they require you to do something or don't require you to do something, that's the as is. When you get that house and you see those windows, that's the as is. And when you close, as is has not been torn up and thrown away. As is still does have its meaning. And I guess the advice would be when you buy a house in these districts, not only to check what's public record, but also when you're doing your inspections, that would be the thing to make sure that there's conformity between their rules, their regulations, and what is presenting itself in the house too. Just want to end really on one thing. Council brought up 2 cases, and one of them in particular was not brought up below. It was brought up in the reply brief. But I think it's important to address these. One in particular was a Torman opinion. And council uses that opinion in somehow or another to say that the silent fraud claim can survive. Well, the Court of Appeals was abundantly clear in that case. The seller was the real estate agent. And what they found is that the real estate agent put that hat on that didn't have the liability. Put the hat on for the seller, that's where the liability fell. So I mean, it's not only distinguishable, it's a totally different case. It actually supports our position in this case. It's not against the agent, it's against the seller itself, who has the duty under the statute, not only of information, but also to go back later and amend. If you have other information, you must, under the statute, go back, even though they're not supposed to rely on seller's disclosure, even though it's not a warranty, even though they give waivers on that, the statute still requires you to do so. Lastly, I would just say to the court, they also bring up the COSAR case. Likewise, that was not an agent case. That was not a real estate broker, an agent case. And as a consequence, again, it not only doesn't support, we're literally one step removed from that situation because we never have a duty that gets triggered in this matter, and certainly not off the information that we are required to disclose. I will rely on the brief for the rest of the argument. If your honors have any questions of me, I'd be more than happy to respond to that. Thank you.
Very much. Mr. Buttle?
Thank you, Your Honor. Just briefly, starting with the Tourman case, I think it's right on point in all honesty. They do hold that the real estate defendants, they distinguish that between the seller. She has two different hats on. One is the seller, one is the real estate agents. And they distinguish right in there between the two. And they say, as a real estate person, you have an obligation to correct the statements made by the seller. And it says right in the case that they can be held liable. I don't understand why it would be any different in this case. As far as an obligation to take a look at the HDC and go and investigate things, I think the law only requires that. I'm pretty sure only when you have some information made available to you that would put something into question that would cause you to have to go research something further. That's the whole purpose of a seller's disclosure statement, that I don't have to go research 35 different things in a seller's disclosure statement to make sure they're accurate before I close on a home. I don't think the law requires that. The law requires that if you receive information that puts you on notice that something might be off, then you need to take a further look. But until that comes across, you don't have to. In this case, there's nothing presented to my client that would give him notice that, hey, I should take a look to see whether the permits were properly pulled by the seller from the HTC. There was represented that it was done in compliance. Therefore, I don't think the law requires him to go take a look at anything further than that. So with that, Your Honors, I don't have anything else unless you have some other questions.
Thank you very much, counsel. This matter will be submitted.
Thank you.
You want to take a break or you want to go on to the next case?
No.
All right, we're going to go right into the 11 a.m. docket and call case number 23. I'm sorry, item number 23, case number 372824-T, Michelle Ann Millman versus Andrew Lee Millman. And it looks like we have plaintiff's counsel that was endorsed for oral argument remotely. Are they on? We have Mr. Falk.
Good morning, Your Honors.
Good morning. All right, counsel, you have 15 minutes.
Thank you, Your Honor. I don't think I'll need the 15 minutes.
We can hear you, but not see you, Mr. Falk.
I don't know why that is. But I'm not very pretty, so, oh, wait a minute, I've got my video crossed out here. There we go. Now you can see me, but probably you were better off before you did. Please the court, Alan Falk on behalf of Michelle Ann Millman in this dispute over attorney fees relating to child support. I'm going to rely on my brief. I'm really mystified why leave was granted in this case, and it took 7 months from the time the application was filed until leave was granted, and now a year to get to oral argument, and that's not your fault. You guys had nothing to do with any of that. I'm just mystified because the sole issue raised by the appellant is why should I have to pay these attorney fees of some $44,000 in a lump sum? And in making his argument, if you look at his brief, he never cites the record in his brief. No part of the record whatsoever. He's appealing, in effect, a series of orders, some of which say, for the reasons stated on the record, thus and so is ordered, and he's provided none of those transcripts. It's just very strange that I'm here in a case like this. When the trial judge made findings, it starts with the arbitrator making findings, that those findings are affirmed by the circuit court. Mr. Millman appeals and then dismisses his appeal. So that was his chance to argue that there was something wrong with imputing income to him. Because what he did, as soon as he was sued for divorce, he quit his employment. He closed his businesses as a home builder and he announced that he was doing it because he didn't want to have to pay child support or spousal support. And then when he's ordered to pay child and spousal support, he keeps not doing it until he's thrown in jail. And he ends up spending $135,000, as he admits under oath in testimony. That's his admission, not me making it up. To try to avoid paying $80,000 in child support. He never pays the spousal support. And he's never going to, because my client is so tired of going to court, she's waived her right to spousal support. It's very sad that I'm even here. So what I'm going to ask you is not only that you affirm the order, he's now had an extra 17 months, or actually 27 months. He was ordered in February of 2024. In February of 2024, he's ordered to pay the $44,000 in attorney fees in a lump sum. He moves for reconsideration. That's denied in April of 2024, but no order is entered until October. He then seeks leave to appeal. That's granted, and so on. So, and the judge is not enforcing the order while she's waiting for this court to decide this case. So he's basically had, more than 2 years extra time to pay this. So he's gotten what he wanted, whether he wins the appeal or not. So my request is that you not only affirm, but that your order of affirmance invoke MCR 7.215 F2 and make the decision to affirm immediately effective. So at least his obligation to pay will be immediate, and he can be put in jail if he doesn't pay. And of course, every time he's threatened with jail, he will pay. So my client will get that much of her money. And then, of course, assuming you affirm, I'm going to be filing a motion for appellate fees, because unfortunately, in another case, Judge Gant has said she doesn't think she has authority to award appellate attorney fees generally. Although I think she did in this case previously, but she's now decided she really shouldn't do that. So I'm going to have to make a motion here to get you to remand for her to, make him pay my fees for fighting this case. Because, my client's supposed to be getting child support. That's what this is all about. And, she's had to fight tooth and claw ever since the divorce to get a dime out of this guy, because he just doesn't want to pay. But he's got a trust. The judge found he has a trust that he can borrow against. That's what he does every time he builds up a big arrearage and he's threatened with jail. He suddenly comes up with a pile of money by borrowing from his trust. Well, he can do that again. It's all his actions that lead us to this juncture, and here we are. If the court has any questions for me, I'd be more than happy to answer them.
We have no questions. Thank you very much, Counselor.
Thank you very much.
This matter has been submitted. Calling item number 24, docket number 375231-T, David Smiley versus Richard Zephyr. Am I saying that correctly? Good morning, Counselor. How much time would you like for rebuttal?
5 minutes, please.
You may begin.
Good morning, Your Honors. This case, Gary Yennerlock on behalf of Mr. Zephyr, the appellant. This case revolves around a deed restriction that was put in place on this 21 lot subdivision in Clay Township along the St. Clair River. And the document says, no buildings to be erected on any of said lots shall be used otherwise than as a private dwelling house. There shall be erected on any of said lots not more than 2 single dwelling houses. Said houses to cost not less than $4,000 each, the location of which shall be as follows. And then it says as to the location of the houses, given the fact that it's along the St. Clair River and that they have to be set back a certain distance. In this particular matter, in the trial court, I pointed out the Thiel decision from the Michigan Supreme Court from 2019 in this type of situation. And you have to look to the language of the entire document versus just some isolated verbiage. And also that if the court is going to grant some equitable relief, that it has to tailor make a remedy that's appropriate for the situation. In this area, we gave you a copy of the plat. The trial court had that. There's 7 lots that have been owned for 20-some years by the Michigan Department of Natural Resources, the DNR for a boat launch. There's 1 house that's an antique shop. Those are obviously commercial activities. The state runs the one. To use the boat launch, you have to pay a fee either each time you launch your boat or on an annual basis. And it would appear that in the trial court, Judge West kind of went off on his own as to his personal philosophy as to short-term rentals. Clay Township adopted an ordinance a few years back regulating ordinances as to short-term rentals, Airbnbs. They basically said you have to have your place inspected. It has to be a house, and you have to have notice as to who would be contacted in case of emergency. And in the Resorts versus Connor case, the court said the court is admonished that courts not interfere with the restrictions that are not expressly provided in the permanent document, that being the deed restrictions, and that historically deed restrictions should be interpreted against the person that's trying to enforce it, so that the free right to use your property is accorded to the property owner, in this case, Mr. Zephyr. On page 14 of the transcript down below, Judge West said back in 1927, then this area was platted and the deed restrictions became a matter of record. Nobody had ever heard of VRBOs or Airbnbs, I suspect. And now that it's about all you hear about and is anybody's desires of renting property, those are the 2 sources that one usually goes to begin their search. And it has grabbed the country with a stronghold. And so it is caused massive change, in my view, in terms of, how those types of operations proceed. Was that anything that was potentially contemplated? Is that in the present use of VBROs or Airbnb properties something that is consistent with the language and the deed restriction of a private dwelling? This is a private dwelling. It's a single family home. Mr. Zephyr, after he bought it, because he lives down the river, he fixed it up and began renting it. 2+ years elapsed before the plaintiffs took this action. They inherited the house. I pointed out in the trial court that there was litigation when the state bought the 7 lots, that was a violation of the deed restriction. The state of Michigan paid compensation to all of the property owners in that 21 platted lot subdivision to allow them to do what they were doing. And it's still in operation. The judge at page 16 said these short-term rentals can cause problems, and there's an issue with reference to the language. And then on page 17, Judge West said, I guess kind of the whole issue or concern with Airbnb type rentals is that there's a constant turnover. There's people coming and going, and you never know who's coming and going and who you don't have an opportunity to screen those folks. And who knows how well they're going to behave. Are they going to be quiet, and how big is the group going to be? Those are things that you just don't know. The status quo with Mrs. Benigni, as I pointed out in the trial court, the neighbor lady's house had burnt down and she rented Mr. Zephyr's house on a long-term basis because there was a long time as to how that fire started. So it's our position that the appellate court decisions favor Mr. Zephyr's use of his property, that he can run it on a short-term basis because he recorded and registered it with the Clay Township Building Department. And there's nothing in the deed restriction that says you can't rent your house. And there's nothing in the deed restriction that says you can't rent it for a particular time frame. And so we would ask that you reverse Judge West's decision, and also to take into consideration the fact that Judge West did not tailor make a remedy. He just said you can't rent your property. He did let the status quo of Mrs. Benigni staying there, and she's still living there because her house is just now being rebuilt. That at some time in the future, she's going to move out and he should have the right to rent it for any time frame that he so chooses, because it is a private dwelling. Thank you.
Thank you, Counselor.
May it please the court. Mark Davidson appearing on behalf of the appellees, David and Cindy Smiley. Quickly addressing the acquiescence, I don't think that any of their arguments of acquiescence have any bearing because they had nothing to do with the violation of the deed restriction here. Under Bloomfield Estates and the other similar cases that are pretty prominent in our jurisprudence, the violation has to be the same or very similar. So the fact that there was a boat launch at the far end and there's a little store in the lot next to that, which is at the far end of the subdivision that my client didn't even know was part of the subdivision, doesn't really raise a valid defense of acquiescence. The latches, that also, this 2-year delay that he mentions, that doesn't have any claim of prejudice. So, latches usually you have to have, some kind of prejudice. In fact, as I pointed out in my brief, it's probably the other way around. He got to get the rent for a couple of years before my clients decided that they had to proceed with the case. The case, of course, focuses on the clause in the deed restriction, private dwelling house. When I did my brief, I had literally copied and pasted from the Phillips v. Lawler case, the whole section in which they interpreted the definition of private dwelling house, and it said in building restriction cases involving covenants, the term private dwelling house, in quotes, means a building designated as a single dwelling to be used by one family. And then it cited a number of cases, and it wasn't until I was kind of getting ready to do my oral argument that I noticed that the years of those cases weren't plugged in. So I went back and looked. The Schatt v. Brill was 1913. Kingston versus Bush was 1913. Gallon v. Brack was 23. And then Seeley versus Phi Delta Sigma was 28. But these cases all were in existence at the time this deed restriction was drafted in 1927. So there already was precedent for defining the term private dwelling house as a single dwelling to be used by one family, which would totally fly in the face of it being used as a short-term vacation rental. I believe Judge West did take into consideration all the surrounding factors of the particular situation. He had access to the map of this plat, very long, thin lots that stretched from the highway going by down to the river. This is the North Channel, which is north of Harson's Island. It's not the channel where the ships go up and down. They go around the south end of Harson's Island. So it's a very quiet, peaceful area, and if you look at the proximity of the houses, I think there's about 8 or 10 feet between these two houses. So again, that does favor an argument of enforcing the deed restriction against having the property used as a short-term vacation dwelling. The fact that the city has the city or the township has an ordinance that regulates them does not trump or override the case law regarding the deed restrictions. There also, I did point out there was another definition in our statutes of Michigan, specifically for the term private dwelling. In the housing law of Michigan statute, they have a definition, classes of dwellings. For purposes of this act, dwellings are divided into the following three classes: private dwellings, two-family dwellings, multiple dwellings. A private dwelling is a dwelling occupied by but one family, and so designated and arranged as to provide cooking and kitchen accommodations for one family only. So we believe that the case was properly decided. There aren't any disputes of facts. It would have to go to a trial. It is true that my client did inherit this from Mr. and Mrs. Winnook, who was Cindy's uncle. This is his old family property that they had even used as family members even before they got the property. So we believe that the decision was correct. The summary disposition was appropriate, and we ask the court to affirm. Unless you have any questions. Thank you.
Thank you very much, Counselor. Rebuttal.
This is an aerial of the property in question. This highlighted part, this was an exhibit. This is the 7 lots that the state of Michigan owns. It's only 21 lots. They're all long and narrow, and where the plaintiff's house is and my client's house was originally part of one lot that was divided. So there's like 2 houses, but it was approved decades ago for these 2 structures. The council makes reference to the housing code and the definition of a private dwelling. The statute basically says it's a single family residential building. It's not multifamily. This isn't a multifamily building. And it also says it doesn't restrict that you who occupy it have to own it. You can rent it. And this is not a timeshare type situation. And the Court of Appeals differentiated that in the Shanty Creek Resort case, where they had restrictions that precluded timeshares, but the litigation then revolved around interim rentals, short-term rentals. And they said you could have short-term rentals. So if you look at all of the appellate court decisions, there's nothing that says you can't own this building, a home, and rent it out for some period of time. And if you're in Clay Township and other townships along the lake, I've lived in that general area all my life. He gave you a good historical section on it. People rent their homes, and there were more rentals. So Clay Township and other communities along the lake put in provisions as to registering them so that they knew who to deal with. So we would ask that you reverse Judge West's determination, allow Mr. Zephyr to continue to have his Airbnb. Thank you.
All right, this matter has been submitted. Calling item number 25, docket number 374560-D, Heritage Pharmacy Services, Inc. versus One Care LTC, LLC. Counselor, how much time would you like for rebuttal?
3 minutes, please, Your Honor.
Thank you very much.
Good morning, Your Honors. Eric Scheibel on behalf of the plaintiff appellant. Before I begin, does the court have any questions of me? I'm going to highlight or accentuate a few of the items I put in my brief, but I can handle any questions if the court has any at this time. All right, thank you. So Mr. Cornell and I have been doing this for a long time, Your Honors. We've had some good old fashioned knockdown dragouts together, and he's newer to this case, but it'll be 30 years for me on Mother's Day that I graduated law school. And as commercial litigators, tortious interference cases are prevalent. They're pled a lot. And when I first saw this case candidly, I thought this was a dead bang winner. I've never seen the type of evidence in writing and then ultimate admissions in the depositions that tortious interference occurred here. And the reason for that is there's no dispute there's a contract. There's no dispute it was terminated. There's ultimately no dispute that my client was damaged because there's 3 years left on the terms of these contract. The issue, and I think Mr. Cornell even laid it out in his brief, is, whether the defendants here intended to induce a breach or did anything unlawful. And when you look
Didn't
at,
it seem like the Mollies wanted to be induced? I mean, they were practically begging for someone to come in and replace your client.
well, Your Honor, that's a good question. I wouldn't say that they were looking to replace our client. What they were begging for was an investment in an additional property that they were going to start.
But that, I mean, whether that was, that was the case, but I don't see how that changes the dynamic. I mean, Molly's basically said, we want a pharmacy to come in, and we also want that pharmacy to invest in, another retirement home or some other investment. And why can't that be just part of the deal that the Mollies wanted?
I would disagree with Your Honor only on a portion of what you just said.
Okay.
Where I disagree is the Mollies didn't necessarily want to get rid of Heritage. The Mollies were looking for investment for somewhere else. There's no dispute. And the deposition testimony is my client was performing admirably. There was no issues. We were servicing, they were behind on payment, but they weren't looking to move us out. The company that we took over for walked out on the Mollies, and they had to bring my client in on an emergency basis. So in this situation, everything was hunky dory.
But wasn't it clear that the Mollies, didn't they repeatedly ask your client, hey, would you be willing to invest in this other opportunity?
I don't know about
your client declined. And so the Mollies went out and found a different pharmacy that would invest in that other opportunity.
They did ultimately, but that doesn't mean that these folks, Mr. Cornell's clients, get to dictate the terms of an existing contract that still had 3 years left on it. This wasn't a situation where it was coming up for renewal. It was on a 30-day notice. There was a 30-day notice, but they couldn't term because they weren't current in the payments. The Mollies had no basis to terminate legally my clients. So what they did is they took the money from Mr. Cornell's clients, then they terminated us and let the chips fall where they may. But there was
to be clear, the Mollies are not on appeal here, right?
That's correct.
Okay. It seemed like the Mollies wanted to breach this contract and get out of the contract with your clients. But that doesn't necessarily mean that One Care
Yes.
induced that breach. It seemed like the Mollies wanted to breach, and they wanted to bring in a pharmacy who would be willing to invest in another opportunity.
Your Honor, with due respect, there was no testimony that the Mollies wanted to breach. What was clear is they wanted money for their other one, and they made a decision based on the emails that we see here that the One Care guys were putting pressure on the Mollies to get rid of my client, Heritage. And in exchange for that, they were going to put the money in. And that's where you see the chain of emails beginning in January 27. And it's appendix number for my brief, 146, 148, 149, that the principals of One Care, Mr. Cornell's client, send a contract over to Mr. Molly and say, here's our contract. When are we going to get ready to go? And he responds, we can't go yet. I need to get right words to that effect with Heritage. And if we don't, we're going to have a big fight. So the implication from Mr. Molly's emails are he wasn't necessarily looking to terminate us. He needed to do right by us. And there are other emails. Mr. Cornell supplies one that there were discussions between my client and the Molly group about an amicable separation, which never occurred because they ultimately didn't pay. So that's where I think there's a distinction with the difference, Your Honor, is we have these emails where words like pressure and we continue to bother folks at the Mollies. These are the One Care folks are inserting themselves into a situation where they know there's a contract. Again, it wasn't open for bid. It was midterm. We weren't in default. They are on notice. Mr. Molly said, we're going to have a big fight with Heritage, not you guys. I wrote a letter, said you guys need to cease and desist. You're on notice, there are contracts. Your sign is on the door of these skilled nursing facilities saying, we're going to take over. So in my view, and that we moved on a cross motion for 2116I2. I asked Judge Ewell to grant it in our favor, and he didn't. And he said, I'm going to deny that. And he granted their motion. So that's why we're here today. I think candidly, we should have been given relief, but at a minimum, there's a question of fact based on those emails, witness testimony, witness credibility, that we're asking this be remanded and deal with it with Judge Ewell. Any further questions?
Yeah,
Thank you.
very much, Counselor.
Morning, Ron Cornell here on behalf of One Care and the Boutros brothers. I'll jump right into it because I think the court has already understood what's happened here. This is business. As Mr. Scheibel and I have litigated many times before and respect each other's advocacy, Eric's wrong. This is business. There's nothing illegal, fraudulent, or unethical about what my clients did. This all focuses on that third element in tortious interference. Did my client's actions induce a breach? Did my clients intend to induce the breach? And were my clients' actions unjustified in law and wrongful for some reason? Because we don't have a per se wrongful act here. It's just a sequence of events that you see in front of you that Mr. Scheibel is trying to argue constitutes some wrongful activity. As the court asked the question of Mr. Scheibel, yes, Molly's wanted out of the deal. In our brief on page 6, we quote testimony from Mr. Scheibel's client, which asked him, he said, you don't loan the money, I'm going to fire you and give it to another provider. Answer, basically, yes, that was the implication. Just as the court asked Mr. Scheibel, they wanted an investor in another property. My clients had no idea what the status of the contracts were with Heritage. The arguments about solicitation, there's nothing wrong with soliciting a competitor's business.
Who did the Mollies approach your clients or did your clients approach the Mollies first?
Molly approached our clients.
Okay.
Molly approached our clients.
Did Molly's approach your client and say, we want you to invest in this other investment? And was it your client who said, well, we're only going to do that if you breach your contract with plaintiffs so we can come in and be the pharmacy?
No, my clients were approached about making that other investment. In fact, there's allegations in the complaint that they had invested in another facility with them in Holly, which is in the plaintiff's complaint. They were not told, we'll only do that if you breach your contracts with Heritage. What the testimony is clear is they said there'll be other contracts available. And my client said, fine, whenever they're available, we'll get in. And then you see the history in the emails and the testimony that Molly was having an issue trying to wrap up with Heritage. My clients were standing back, waiting to find out. The so-called pressure was finding out, when are we going to transition to my clients? When are we going to transition the business? So there wasn't any, you fired them and we'll take over. My clients had no knowledge of the terms of the contract with Heritage. Soon Mr. Molly was taking care of things. And we simply were asking not to pressure anybody, but to say, listen, if we're going to transfer pharmacy services, we're going to do so in a transition way that we normally do. We need to let everyone know how this is going to happen.
Is there anything in the record to suggest that the Mollies were displeased with Heritage in terms of the pharmacy, as opposed to the Mollies being displeased with Heritage that they weren't willing to invest in the other projects?
I don't believe there's record evidence that as of the time they were talking about it, there was a problem with the services being provided. There was a problem, as you can see from the testimony and the emails, of unwinding the transaction, whatever that unwinding was. Molly was late in payments to Heritage. I don't know if
But that was further down the road.
That was further down the road.
But all I'm asking is, was there anything that where Molly's indicated that Heritage had been performing deficiently as a pharmacy?
No, not that I can see in the record.
So it really does seem like everything hinged on the willingness of their partners to invest in this side project.
From the Molly's perspective, maybe. From my client's perspective, they had invested with them before. There's another investment. We'll throw it in investment. Hey, when these contracts become available, we'll step in. We'll be the pharmacy. They didn't step in intending to breach or cause a breach of that Heritage contract. They didn't intend that what their actions were designed to cause the breach.
the solicitation of the business, sending over your business contract. I mean, be realistic here. I'm sending you my business contract. I'm going to start with you. That's tort. That's unethical. That's fraudulent. He sends the business contract over. He says, can we transition? So there's nothing, when you peel it away, this is competition. These guys are competitors. My client took advantage of a situation. His client was offered it first and declined. He was said, if you don't invest with me, I'm going to fire you. That's Molly to them. We had nothing to do with that. That wasn't our issue. So Judge Ewell hit it right on the head. He looked at the deposition testimony. He looked at the emails, and he concluded there's no evidence to support a claim for tortious interference, whether it's contract or business expectancy, because there's no evidence of anything illegal, unethical, or fraudulent about what occurred here. We ask that you affirm Judge Ewell's ruling.
Has there been a determination yet as to whether there even was a breach by Molly and his companies, or is that being litigated still, or?
That was litigated after we left. So this is the issue. We left the case in we left the case a few years after you continued litigating with Molly. Yeah. So we left the case a couple of years ago. They continued to litigate with Molly. I don't know what happened. Frankly, I don't know.
Because I mean, the summary disposition was granted in 22 or something.
Yeah.
And it seems odd that we're now here 4 years later.
Yeah. You want to address it?
Address that on rebuttal, Your Honor. I'll let Ron finish.
That's okay.
Yeah, I can answer both those questions.
Okay.
Yeah,
thanks.
yeah. So the truth is we've been out for so long, and then when the dismissal came and then Eric filed his notice, I was like, whoa, this is going back a ways. So anyway, I appreciate your time.
Thank you.
To answer those two questions, and this case was literally filed on, I think, right around Halloween, and first responsive pleadings were motions dismissed and COVID hit and everything sat. So that's part of the reason why this thing took so long. But to answer Your Honor's question, yes, there is an order entered on my motion for summary judgment on the contractual issue that the Mollies were in breach. Judge Ewell entered that order. That's in the case record. So that has been determined.
So you have a judgment against Molly or his entities for a breach of contract.
That's correct, Your Honor. Yeah. And so that's why that's not a dispute. There's a contract, there's a breach. We have damages because there were 3 years left on the tail. The only question is why we're here today. And Your Honor, I forgot. I'm sorry. What was your question?
I just found it curious that the motion for summary disposition was granted in 22 and we're hearing the appeal 4 years later. It seems.
Because we're continuing against the Mollies
That's fair.
and other parties, and then there were substitutions of counsel, and then counsel withdrew, and so just the case
Okay, that's fine.
meandered. Yeah, nothing else happened. So, Mr. Cornell, I was about to say Ron, we know each other so well. Mr. Cornell said three things which is the point that we tried to drive home in our brief. The first, he said his clients were standing by, waiting, and not putting pressure on. Well, the opposite is what his clients wrote. If you look at my appendix 146, it's the email with the contract. And of course, sending a contract to somebody is not tortious interference. I'll acknowledge that. But when you know, and you've been told that the contract isn't up for bid, there's no RFP, it hasn't been terminated, it's aggressive for sure. But when Mr. Cornell's client says, we haven't heard back from Pam, who was a Molly Mission employee, on the changeover date for your facilities, I hate to keep putting pressure on her, but we really need to know in order for us to strategize accordingly. That's January 5 of 17. That is right at the beginning of this process. So the pressure must have started before Christmas because he's running on or about one of the first business days of the year. If you look at 148, again, Mr. Pierre Boutreau says, we're trying to get up and running. They had access to patient HIPAA information. They went in and had access to these facilities, even though they didn't have a contract. That's a whole other issue. Mr. Molly says on January 25 of 17, Pierre, I understand, but we will end up on sick, big fight. Let's talk today. I'm paraphrasing. Mr. Boutros is confused why the fighting. And Mr. Molly says to Mr. Boutros, meaning big fight with Heritage, not you guys. There are other emails where Mr. Boutros and Mr. Molly are emailing each other about, we need to clean these things up. We can't push. I have to clean the slate, or I have to reconcile bills with Heritage. It was clear, or it should have been clear to Mr. Cornell's clients that there was an existing contract and their actions were pushing the breach. There was no other reason from a contractual standpoint, Your Honor. We were performing And the Mollies testified there were no issues with the performance. In fact, they were in breach because they didn't pay it. So given those facts, again, we ask this court to reverse and remand to the trial court. Thank you.
Thank you very much. This matter has been submitted. Calling item number 26, docket number 372997-D, estate of Calvin McWilliams versus Citizens United Reciprocal Exchange. Good morning. How
Good morning.
much time would you like for rebuttal?
I'll reserve 5 minutes.
Are we still morning?
2 minutes.
2 minutes. That's-
I checked.
Never know. Never know with the 11 o'clock call when it's gonna finally come. Good morning, may it please the court. Courtney Evans here on behalf of Appellant Cure. This case has been thoroughly briefed through an application for leave to appeal, which this court graciously granted, and as well as on the parties' briefs on appeal. So today I'll mainly rest on that briefing, but there's 3 key points that I want to highlight for the court, as well as answering any questions the court may have. At its core, this case is not asking the court to address the merits of Cure's rescission defense. This case only asks whether striking the rescission defense as a discovery sanction was both fair and just in light of the circumstances of this case and the factors established in Dean versus Tucker, including the availability of lesser sanctions. First, I'd like to address that the trial court's order sanctioning Cure by striking its rescission defense as a discovery sanction did rise to the level of a default as to Cure's liability and should have been reviewed under this court and the Michigan Supreme Court's factors addressing as such. In prior
Is that because that's literally the only defense you have?
That's correct. In this case, Cure repeatedly stated in the hearings and on its briefing that this was the defense to the case, even though
Not, but I want to be clear, not the defense, but the only defense. Is that the position that Cure is taking?
there are other defenses that are raised in this matter. However, the defining kind of distinction between those is that this defense is a complete defense. If Cure is successful in proving rescission and
you don't have any other complete defenses?
There's no other complete defenses. All the other defenses.
And would not, I mean, I guess technically that would be a defense. If we do agree with you, from Cure's perspective, what is the proper sanction then?
So at the hearing, Cure's counsel said that this should be dealt with using monetary sanctions because the conduct that's at issue here is the production of allegedly the improper individual for one deposition. There was, allegedly some minor delays in getting the depositions, but these are all things that are in fact regularly dealt with using monetary sanctions. And in this case, what the trial court did is Judge Heisey essentially recognized that the validity of Cure's rescission defense, whether it should be stricken, that should be dealt with on summary disposition on a proper motion where both parties get to present their evidence. And instead of allowing it to go to summary disposition, the court struck it as a sanction. And that, we argue, rises way above the level of the conduct that was at issue in this case. That's under the governing law, especially the Dean versus Tucker factors. The key determination that the court needs to make is whether the underlying conduct justifies the sanction. And that is what all the factors are supposed to get at, is whether the sanction meets the conduct. And in this case, as the lower court recognized, the striking of the defense should be addressed on summary disposition, but instead went way too far and granted this defense, which, as I mentioned, essentially is a default as the Cure's liability in this case. There's a number of cases that this court has issued that state that the most severe of sanctions, which we're arguing is in this case, should be exercised cautiously. The cases that justify these types of severe sanctions often involve wanton and malicious misconduct, general failures to participate in discovery in good faith over years. For example, in Kalamazoo Oil versus Borman, 242 Mishap 75, the trial court found that the defendant's conduct evidenced, quote, a disdain for the authority of the court and expressed unwillingness to cooperate or participate in discovery.
I'm sorry, can I ask a question? The trial court uses the term hide the ball. You guys are playing hide the ball. Is there anything beyond this particular circumstance that you are aware of that the court might have been referring to?
To my understanding and in the transcripts of the hearings, the two issues, I guess I say two issues. The main issue was with the deposition of Cure's underwriter. And in all of the trial court did deal with a motion to compel Cure's underwriter. And then when Cure's underwriter was produced, Mr. Sullivan, he was Cure's manager of underwriting investigations. Plaintiff's counsel took issue with him being produced instead of the underwriter who wrote
And I
this.
understand that.
Yeah.
And that's in the briefing. My question is there anything outside of this particular circumstance that the court might have been referring to?
Not that I'm aware of. The court didn't reference any longstanding failures to produce discovery, malicious intent. To my understanding,
Plaintiffs have to file a motion to compel.
plaintiffs did have to file a motion to compel. Cure responded with a motion for protective order, which was
And didn't, before the motion to compel, isn't there record evidence that plaintiff's counsel repeatedly asked for deposition dates and your client dragged his feet?
That's correct. That's what the court found, is that there was delays in getting the depositions. And once Mr. Sullivan was produced for the deposition, he was, as plaintiff argues, not the correct individual. However, I'm not here to say that what Cure did was perfect in producing.
So you're acknowledging some penalty would be appropriate. It's just you think that dismissal of that affirmative defense went too far.
That's correct.
Okay.
And as Cure's counsel mentioned at the hearing, and as I previously mentioned, this type of situation is often dealt with using monetary sanctions, something that does not rise to the level of what is essentially granting summary disposition as to Cure's rescission defense, and essentially, because this is their core defense, default as to their liability. The final point I'd like to make is that the trial court, again, failed to consider the availability of lesser sanctions, even when suggested by Cure's counsel. And this court has previously held that the trial court must consider the availability of lesser sanctions. The opposing counsel in the briefing has claimed that the trial court did consider the availability of lesser sanctions, but that isn't supported by the record. There's no indication in the hearing that the trial court did, in fact, weigh these sanctions. Cure's counsel suggested the sanctions before the trial court even discussed Dean versus Tucker, and the court then walked through some of the factors, but notably left out the availability of lesser sanctions factor. The core question here is whether the sanction of striking the rescission defense was just and proper under the circumstances of this case, and we argue that it was too severe given all of the circumstances. Thank you.
Thank you very much.
May it please the court, John Kuzman on behalf of the plaintiff appellant or plaintiff appellee, and we have the other appellee who will be splitting the argument.
And what is your time split going to be?
We'll split it in half.
15 minutes? Okay.
Your Honors, we believe the trial court's exercise of its discretion to strike the rescission and affirmative defense was within the range of principled outcomes. To go back to one of the questions already raised, it's not, the rescission defense is not Cure's sole defense. We know this because after their rescission defense was filed, we filed MSDs, and they were on the PIP no fault side and on the uninsured motorist side of the case, and they were both contested.
Here's part of the problem I'm seeing is that I get your client's frustration with Cure at the beginning when they were dragging their feet. But then, if I recall correctly, they said, okay, we're going to provide Mr. Sullivan and I think one other person, but we're not providing this other. And the judge said, okay, that makes sense. And then they produced Mr. Sullivan. During the middle of the deposition, you learn that Mr. Sullivan might not be the best witness with regard to underwriting. You then have a hearing, maybe there's a motion to compel. That would seem to be a very opportune time to say, just provide the other person. We found out during the deposition, this isn't the right person. That happens all the time without defenses getting thrown out. It seems like the penalty went from 0 to 11 immediately when maybe a 4 or 5 level penalty was more appropriate. So how can you explain why that just jump in sanction is appropriate?
Especially when I think Cure offered that other person, didn't they?
Yes,
And you said, no, we want to go argue the motion.
they offered Denise Guest, whom we both are referring to as an alternate individual. And the argument during the motion, as it develops, Denise Guest is raised as, okay, we want this, we're proposing this as the workaround. And defense counsel then proceeds to effectively explain that Denise Guest isn't going to know anything more than James Sullivan. So at that point, I think that's what triggers in the trial court's mind, okay, this is the high ball situation. You're saying your cure is trying to cure it's providing the wrong person for the deposition and offering someone else who doesn't know anything additional, who won't have anything else to offer, which is significant when you're trying to battle against a rescission defense with, a party who's unrelated to the accidents passed away, and we're trying to uncover what are the ultimate, questions and answers. What is going to go to what misrepresentations would justify the rescission?
Well, but I mean, you knew, I don't mean you personally, but plaintiffs' lawyers writ large, you all knew that it was Guest who actually made the decision to rescind the policy. Now, Mr. Sullivan may have been informed of all the information and then therefore was able to testify about it. But I mean, if you wanted the person who actually did it, it was Guest. And it just seems like, regardless of what Cure was saying, that's who you wanted to talk to all the time. They thought Sullivan would be better. You didn't think so. So they said, okay, well, you can talk to Guest. But instead of saying, okay, let's go talk to Guest, it was, no, just throw out the defense. That seems like a harsher penalty than what was called for. But what are we missing? I mean, you heard Judge Switch's question. What are we missing? Like what was more nefarious and frustrating for the trial judge that we're just not seeing from this cold record?
Sure, and we, get the opportunity. As you noted, the record reflects that we asked for Guest. They say, no, you need to talk to Sullivan. They say this in the motion. They say it's at the motion to compel. Sullivan's your guy. He's not the guy. So, why are we now? We're to presume that Guest is suddenly going to be the person we want to hear from, and then we get through oral argument at the sanction hearing, and they indicate Guest doesn't have any more information.
Well,
So
Guest was the underwriter, however, right? And that's what you wanted to depose the underwriter. But what she couldn't testify to is what was said during the phone call. Do I have that right?
Right. If we're going to get to the portion of for Cure to get from, there's misrepresentations, right? We need to get, this isn't the situation where I filled out an application, it's a yes or no question. You said yes. The answer was no. We would have charged a different premium, rescinded. We have, somebody who's changing his address midstream. There's multiple conversations, and how these conversations kind of play out and what kind of questions are being asked and how they're interpreted is.
And you had the recording of the telephone call, if I recall correctly.
And I think that, yes.
I mean, and I get, I think plaintiff's counsel, you all took the position below that, well, that won't get in at trial. But did you just ask Cure and say, would you consent? Would you agree to have this admitted at trial if it does get to trial? That would have seemed to have solved that problem, right?
we need to understand in the course of discovery, what are they actually going to rely on to back up the defense? Because a free-flowing recording, it's not necessarily
And
clear enough.
you don't think talking with Sullivan, talking with Guest, and then having the recording, that would not have provided the sufficient context to understand the recording and understand Cure's decision?
Not if they're not the ones who have been listening to the recording and being like, and undertaking a conclusion, okay, this turns out this answer is not comport with the facts that we are uncovering in our own investigation.
Well, couldn't Guest have testified to that, even though she wasn't the person who took the phone call?
Could she have testified that?
He could testify as to their decision making based on the communication.
Yes, she could have if she had actually listened to the recordings, but that's what came out at the hearing, the sanction hearing. She hasn't done that either. She just gets an SIU report and rubber stamps it.
Is it possible that no one from Cure ever listened to that recording? And wouldn't that be part of your defense? I mean, your attack on their defense to say, they have this recording, nobody actually listened to it, therefore this rescission is inappropriate.
It would be my concern that we raised in the brief is now I don't have the universe of individuals or who may be put forward.
Isn't that just an interrogatory to Cure? Say, tell us all the people who listened to this recording.
That would effectively do it. The posture of the case, we weren't in a position to do more written discovery based on the scheduling order, and we were, put it in front of the judge to say, hey, they dragged their feet, they produced the wrong guy, they told you this was the right guy. A sanction is appropriate. Here's why we think this is the appropriate sanction. I think part of this case is where Dean v. Tucker gets mapped onto a situation like this. And I do think there's not notice to hold that Dean v. Tucker factors must all be discussed and rigorously applied in this situation is an extension of the law. That's Cure's argument, but we don't think that there should be, such a rigid approach, turning the sanctions into a box checking exercise.
I tend to agree with you. I've seen in too many cases where Dean has turned into a box checking exercise. But with that said, it seems like something that would have been very material to talk about on the record would be alternative punishments or sanctions. Why would a monetary sanction be insufficient here? It just seems that would have been a necessary part of the Dean calculus that should have been discussed on the record. Is there any place in the record that we can find where the trial judge indicated that monetary sanctions simply wouldn't be sufficient?
You won't find the trial judge explicitly stating it. You'll find in the hearing transcript monetary sanctions being suggested and the trial court saying something to the effect of, a minute ago you told me that you hadn't done anything wrong and now you're saying I'll take the sanction. So to me that implicitly suggests that the trial court considered and rejected that option. I will cede the rest of my time to their appellee. Thank you, Your Honors.
Morning, Your Honors.
Good morning.
Abe Newhouse on behalf of the defendant appellee Titan Insurance Company, who is the assignee of the MAIPF in this case. Obviously, we have a vested interest in the rescission here. And I do agree that this is it is a drastic sanction. However, it's clear it doesn't
rise to the level of a dismissal, right? The cases that Cure relies on here are Dean v. Tucker, where they were precluded from calling any witnesses, right, for failure to file the witness list. Same deal with DeRay Development, except for in that case, it wasn't even considered dismissal. This court remanded it back down to see if plaintiffs could actually carry their burden with the witnesses and evidence that could be called at trial. And then finally, in Vincenzio, there was an issue with notice of trial and a party failed to appear, thus warranting dismissal. Here, to your point earlier, Judge, this is a striking of one affirmative defense. There were 43, I believe. So there's still 42, if my math's correct, defenses on which Cure can rely. Additionally, this is obviously governed by the No Fault Act, right? So plaintiff's going to have to carry their burden of proving it arose of the accident, which related, necessary, reasonable, all that. As far as the complete defense, we've all read our insurance policies. There's a laundry list of exclusions, fraud being one of them, right? Obviously, I don't have that in front of me right now, but there's plenty of exclusions under a policy of insurance that would provide a complete defense. Like Brother Counsel pointed out, the issue here was right out the gate, Cure filed an SD regarding rescission, right? And the trial court said, hey, let's do some discovery. Let's figure this thing out first. The discovery was, let's get the underwriter. They get to the underwriter's depth and he testifies, and I quote, I am not an underwriter, right?
But he's an underwriter investigator.
He's an SIU investigator into the underwriting process. So,
right. And I mean, in many respects, he would be a perfect witness, but he might not be the perfect witness here. I just, it's not like they produced someone in finance who has nothing to do with underwriting. I mean, they produced someone who has a lot of relevant information, maybe just not all of the relevant information. So I don't know that producing Sullivan was some dramatic error that they made. But I'm more interested in when they offered up Guest, why wasn't that just a nice intermediate step of, okay, this will advance the litigation. That's who that's who plaintiffs have been asking for anyways. Let's produce her and see what she has to say.
Sure. And as Brother Counsel pointed out, it was the disposition of the scheduling order, right? They had come out, they had filed an SD. The judge said, hey, let's get the underwriter. Then the case dragged on, I believe it was a year. We had already passed discovery. Then they said, okay, fine, we'll give you Guest, right? Discovery had been closed, and who knows what other discovery would have had to happen after the death of Guest, right?
Well, they wanted to figure out who actually listened to this recording. That seems to be the big hubbub. And that's a simple interrogatory. I mean, that's literally one interrogatory. Tell us everyone in your company who has listened to this recording. Then you get the list. Then you decide who to depose. I don't see why we're making this harder than what it seems.
Sure, right. But the reason the underwriter needs to be called in a rescission case is you have to prove either A, that the policy wouldn't have been written for those misreps, or that the premium would have been higher, right?
Well, I get why they wanted to talk with the underwriter. That makes perfect sense. But they also seem to want to talk to everybody who listened to this recording. My only point is that's an easy answer to get with an interrogatory. Then you can make a decision on whether you want to depose those folks or not. But I don't see the point of, well, they offered us Guest and she wasn't good enough. I mean, she was the underwriter. And even if you had to talk to a third person who may have listened to the recording, okay.
Sure. And like I said, I believe the point was that the case was dragging on at this point solely due to Cure's, producing of James Sullivan, which they claim is innocent, despite the fact that it's very clear that plaintiff wanted the underwriter, not an SIU investigator who investigates claims after they're made, right? They want the underwriter who can speak to why the policy was issued and why the policy premium was what it was. I just like to conclude by pointing to the case that I cited, Tollis, right? Tollis, the trial court didn't go through a robotic checklist of the Dean v. Tucker factors. They didn't say, right, 1, 2, 3, 4, 5, 6, 7 regarding the sanction of staying the case and providing and requiring plaintiff to provide monetary penalties there. Instead, what happened was the trial court was very well aware of all of the alleged misappropriate conduct of the parties in that case. And what this court did was they held the totality of the circumstances, looking through the entire record, that several of the Dean v. Tucker factors were actually spoken about. Noticeably absent from that particular section of Tollis is whether a lesser sanction was warranted. But regardless, this court held that under totality of the circumstances, it did not fall outside the range of principled outcomes, and there was no abuse of discretion. So I think this court, looking at the totality of the circumstances on the record, this particular sanction did not fall outside the range of principled outcomes. Therefore, there was no abuse of discretion. And we would ask that the court affirm. Obviously, if you have any questions, I'd be happy to answer those.
No
Thank you
further
very
questions.
much.
Thank you very much. Rebuttal?
Thank you, Your Honor. Just a few points that I would like to address. First, I believe Judge Schwartzler, you said it perfectly. This was a situation where the sanction went from 0 to 11. If you look at the transcript of the
It's a
hearing.
Spinal Tap reference for those who may not be aware of that.
If you look at the transcript of the hearing, you have on page 14, Judge Heisey saying, I think what we have here, Mr. Mays, I'm sympathetic, but I think what I need is a summary disposition on that issue with all the deposition testimony attached. And on page 17, her saying, never mind, I agree with you, Mr. Main, I'm going to strike the affirmative defense. So it really was a situation where the court went from 0 to 11 very quickly, changed her mind on the defense with really no underlying indication that there was such nefarious conduct that warranted this significant of a defense. Also wanted to address the issue of Ms. Guest's deposition. Opposing counsel has addressed the fact that they concluded that it was not going to be worth their time to do her deposition because there was some indication that she reviewed the same information. However, this is all premature. Nobody knows what Ms. Guest is specifically going to testify. However, in Mr. Sullivan's deposition, he stated that he reviewed Ms. Guest's determination to rescind the policy. And so clearly she had some other information that she could have given here. What we have is that, as the trial court stated, there should have been a motion. They should have deposed Ms. Guest. There should have been a motion for summary disposition on rescission if they believed that Cure still didn't have sufficient evidence. But the court instead decided to strike this as a discovery sanction, which was far too harsh. I also wanted to address the statement that, sometimes Dean versus Tucker can get into a box checking exercise. But I wanted to note that at the hearing, what I believe to be the two most important Dean versus Tucker factors in relation to this case were not addressed at all. And that's the availability of lesser sanctions. And the other one is the attempt to cure. And that is weighed heavily, especially when in this case, Cure said you can have Ms. Guest, we'll allow her deposition. And there was this indication that, she was going to be the person maybe they were looking for following Mr. Sullivan's deposition. But again, plaintiff just decided to throw their hands up, file this motion, and not just depose Ms. Guest. Finally, I just want to address, opposing counsel addressed the Tollis oil and gas decision. And in that case, you do have a situation where there is this nefarious conduct. The court, there was a motion to compel in that case, which the trial court found was, quote, so devoid of any substance that it permitted the interference that plaintiffs deliberately submitted a deficient response. So in that case, there had been 2 years of them trying to get information. They never provided that information. And so Tollis, again, shows that type of nefarious conduct that's necessary when you have such a significant sanction. So we just ask that the court reverse, and thank you so much.
Yep.
Thank you very much. This matter is submitted. Calling item number 27, docket number 377071-D. Courtney Kelly Hutchins versus David Deshaun Wilson.
Good afternoon, Your Honor. Kevin Gentry on behalf of the appellant. 5 minutes for rebuttal, please, but I can't believe I'll use all the time anyway. It's late in the day. Your Honors, before I get to the actual legal errors in this case, I want to point out one overriding fact. This is a 26 overnight case. In 27 years of doing family law appeals, I've represented some concerning parents and a couple lousy ones. And I can't recall any non-supervised parenting time less than 26 overnights. And yet this was supposedly reached on a clear and convincing, where there were 2 factors favoring one side and one factor, factor J, which is usually the determinative factor in whether or not a child should be twisted into a pretzel, favoring my client. And that's a real problem. And I'm not even sure that there was a clear and convincing finding here. There was a talk on page 4 that that's the standard, but there was a talk on page 6 that was just the finding of the best interest. So I don't even know if there was a clear and convincing factor here, but this court might say there is because she used the past tense on page 4.
Is the child over 3 now?
I honestly don't know the child's birthday, Your Honor. I intend to.
Oh, I saw 2 parents nodding their heads no, so
Yeah,
I think they probably know.
I think they know, Your Honor.
But am I correct that at 8, geez, wow. Is it at age 3 that the increased
At
time?
age 3, it jumps up to 40,
I guess just
52. It's a 52.
How many more months for the child before the child's 3?
Yeah, it's a 52er in September. And again, I think 52 is quite low for a child this young, because the reality of this is that the court found there was an established custodial environment with both parties. If we have a both parties established custodial environment, why are we not raising a child with both parties? That's a huge change. There's a Lieberman change here, but this is really a case where there is a overarching problem and 2 legal errors. I think I've addressed the first legal error as far as the clear and convincing. If Your Honors look at the past tense of page 4 and say that's enough, okay, that's enough. If Your Honors look at what the judge found on page 6, it's not. And either way, on a 2-factor community record and home environment for the mother, 1 factor J, willingness to facilitate for the father, and the rest either equal or non-applicable, I don't know how this becomes a 26 or even a 52 overnight case. Not for a child this young who needs to grow up with both parents, and can, because they're still adaptable age. As to the other legal error, Your Honor, I've raised a few pro per cases over the years, Your Honors, involving cross-examination, and every one but this one has failed because of one thing. My client had nothing to say at the time when the judge asked. Here, the judge didn't ask. The judge asked the plaintiff mother if she had anything else, and she did. She wanted to cross-examine the defendant. He never got his chance. He was never asked that. The court went, I'm going to interrogate the mom. I'm going to interrogate the dad. I'm going to ask the mom if she wants anything else to do anything else. And she said, and then he never got to the point of, Father, do you have anything else? No, it was, okay, the court's going to issue a written decision. Have a nice day, everyone. And that's a problem. You know, impropers are really hard, and Wayne County's got like 70% of the cases are improper before the judges, I'm told. And that's really hard. But if you're going to offer cross-examination to one side, it really has to be offered to both. And it probably has to be offered to both anyway, because there is due process even for improper parties. And that's really my positions here. Thank you, Your Honors.
Thank you very much.
May it please the court, Courtney Hutchins, appearing in pro per for plaintiff appellee. Your Honors, the trial court did not commit a legal error. The defendant appellant raises 2 primary issues on appeal: that the trial court improperly changed the established custodial environment and that he was denied due process and a fair trial. And both claims are unsupported by the record and a misstatement of the law. Regarding issue number 1, there was no improper change to the established custodial environment. The defendant argues that the trial court committed reversible legal error by changing an established custodial environment with both parents to sole legal custody with the plaintiff. And that argument fails for two reasons. One, it mischaracterizes what constitutes as a change. And two, it misstates the factual record. A change does not simply occur because parenting time is adjusted. As the court explained in Merrick versus Merrick, there's only a change if the modification alters whom the child naturally looks to for guidance, discipline, the necessities of life, and parental comfort. And the Michigan Supreme Court in Sabatine versus Sabatine made clear that this is not a mathematical calculation as stated in defendant's brief. Time is a factor, but it's not determinative. And still that time calculation must be factual, which the appellant got wrong as outlined in my brief. The trial court did not change the custodial environment. The trial court found an established custodial environment with both parents, which is not disputed. And the court's order did not change that environment. There were no prior custody orders. And the child primarily resided with the plaintiff since birth. The defendant had limited non-overnight parenting time prior to trial. And the court then implemented a structured parenting time schedule under the Wayne County Co-Parenting Time Plan, which expanded the defendant's parenting time overall by adding overnight parenting time. As opposing counsel mentioned, it was 26 nights, which will be increased to 52 nights as of age 3. It increased the structure and the consistency, and that did not change who the child looks to for care and comfort. It reinforced stability while expanding the defendant's role. It's also critical to distinguish between physical and legal custody. The physical custody relates to where the child resides. The legal custody relates to the decision-making authority. And here, the trial court awarded joint legal custody, preserving both parents in major decisions. And the designation of plaintiff as the primary physical custodian did not eliminate the defendant's role. It simply formalized the child's existing residential stability. In conclusion, on issue 1, the defendant's argument is based on a misstatement of both the law and fact. There was no change to the established custodial environment, and therefore there was no clear legal error. In regards to issue number 2, there was no violation of due process. The defendant claims he was denied due process because he was not allowed to cross-examine the plaintiff. And that argument fails because there was no denial, because there was no request. Due process requires a notice and a meaningful opportunity to be heard, and that standard was fully satisfied here. The defendant had a full opportunity to be heard. As the record shows, the defendant testified under oath. He was questioned by the court. He had the opportunity to present evidence and witnesses. The plaintiff called the defendant as a witness, and he was examined. And at no point did the trial court restrict his participation. Defendant, in his case brief, relies on HMM versus JS, which is distinguishable. In that case, the court affirmatively denied cross-examination. That didn't happen here. The trial court simply proceeded based on the party's own presentation of evidence. And litigants proceeding without counsel are still bound by the procedural rules of the court. There was no cross-examination because the plaintiff was never called. He did not list the plaintiff as a witness. He did not ask the court, or he did not call the plaintiff to testify, and he did not request to examine the plaintiff. Cross-examination requires that the witness first be called, and that never happened here. The defendant submitted briefs. He had the opportunity to submit a witness list. He never listed the plaintiff as a witness. Ineffective self-representation is not a grounds for reversal, and the trial court cannot be responsible for the party's strategic decisions. And additionally, and importantly, under the raise or waive rule, issues not raised at the trial court level are unpreserved for appeal. The defendant raised no objection.
The raise or waive rule is not applied in child custody matters. You're right generally that in civil matters, we look at raise or waive, but we modify that in certain areas, especially involving children. So TPR and child custody, we apply plain error. So we're going to look at it, but your arguments are still well taken.
Thank you. I'll note that for my future reference. And as I close, Your Honors, thank you again for that information. Overall, the appeal is grounded on factual inaccuracies and legal misstatements. The trial court did not alter the established custodial environment. They did not reduce the defendant's parenting time, and did not deny the defendant due process. And for those reasons, plaintiff appellee respectfully requests that this court affirm the trial court's order in full. And I'll take any question. I'll be happy to address any questions that Your Honors have.
No questions.
Okay, thank
very
you so much. Have a good day.
Your Honors, the child did not benefit from any overnights with the father before the litigation began for a simple reason. Mom didn't allow him. The court found that the child naturally looks to both parties, established custodial environment. 339 versus 26, 313 versus 52. By the time the child reaches 5, 6, whatever, because we know about Varka, this isn't going to change absent something really bad happening to the child, which nobody wants. Who's the child going to naturally look to? This is a young child who should be seen with both parties. And that's really the biggest problem here. As far as the denial of cross-examination, the trial judge elected.
I think it's more appropriate to say there was a lack of offer.
Lack of offer.
Yeah,
And
I mean,
think that's
there
fair.
wasn't an affirmative.
No, there wasn't affirmative denial. Your Honor is exactly correct. But the trial court elected, I'm going to examine mom. I'm going to examine dad. I'm going to let mom do her thing. And then there was just a close the book and walk away.
The problem though I see is that the argument is that, well, if cross-examination had been offered and accepted, that then the mother would have been made to go, I think the word was off script, and would have to address the points that the father had brought up. I don't know what that means. And in any event, I thought the father did a very good job of bringing up his arguments and bringing up the points that he wanted to. I mean, I don't think the trial court, I don't think if there's any error, I don't think it was because the trial court wasn't adequately informed. I thought both parties did a nice job of, here's all the things we want you to consider, Judge. So I'm a little unclear about the lack of cross-examination and how it was, a due process violation requiring a do-over.
Your Honor, there's one issue we haven't talked about here. I mean, certainly the plaintiff presents very well. Probably not when she's examined by the defendant, but that's a bigger story. The bigger problem is that there's another child in the plaintiff's house, an 18-year-old now, daughter who's now an adult, who really doesn't like this child. And that wasn't brought up at all other than by the defendants. And very few cross-examination questions on that would have exposed the fact that the home stability record, that factor D that went for the plaintiff, wasn't really there. And that's the issue that didn't get explored, Your Honor.
Okay. Thank you.
Question?
With that, Your Honors, I'll leave it with 313 and 52. Who's the child going to look to? Thank you.
Very much. This matter has been submitted. Calling item number 28, docket number 370491-D. People of the State of Michigan versus Robert Ramsey. No one is endorsed for oral argument on this matter, so it shall be submitted. And with that, that concludes our docket for today.